as well as our society. And arguably, it could say that researchers here at University of Moratuwa are in that dire thirst of finding new information, figuring out new things. And we always try to make sure that something innovative or some sort of innovations to come out of our research. And so there are a lot of dedicated researchers here. And imagine for a moment, you are such a dedicated researcher and you don't eat well, you don't sleep well, and you give your 100% to this research. And at the end of the day, you reach your pinnacle of success and you get that expected outcome. You would be as happy as a lark because that's the best feeling that a researcher could get. I hope everyone agrees with me. But the next thing that sleep deprived, starved is someone else has come and commercialized your research finding or your innovative, creative idea, and there is nothing you can do. The research that you have put your 100% belongs to someone else, and you don't have anything to do with that. At that sort of situation, what can we do? What are the rights that we have? What are the laws in Sri Lanka that protect us as researchers? What is the role of trademarks and patents here? And in the coming future, what sort of methods or what sort of things that we could take to mitigate such situations? A lot of questions, unfamiliar situations, murky water, tangled laws, and we are confused. And that's why, as researchers, we also should know something about intellectual property rights. And that's why today's session on fundamentals of intellectual property law, protecting ideas in a knowledge economy, is all about protecting your intellectual property laws and learning about what intellectual property law and what are the rights that we have. So I'm very pleased to announce that we have a very experienced resource person today joining with us. So our resource person is a professor as well as the head of the Department of Legal Studies, Faculty of Humanities and Social Sciences of Open University of Sri Lanka. So I invite everyone to join me, welcoming Professor Sanat Samira Vijay from Open University of Sri Lanka, our resource person. Let us give a good round of applause and welcome.
Thank you very much and very good morning. So it's so nice to see your enthusiastic faces. And so thank you, Professor Gayatri, for inviting me to this occasion. And it is a privilege, as I said to you earlier. So this is the very first time of me being here in University of Moratuwa. And so without further ado, I think we can just continue the discussion. So if you have any question or if you need to get any clarification, so you can just ask me. I'll be able to provide some clarifications and I'll be able to answer some of the burning questions that you have, as very correctly mentioned by your colleague who introduced the session. So when we look at the topic, fundamentals of intellectual property law, protecting ideas in a knowledge economy, so that the topic can be directly linked with this quotation: the nation which does not create new things will not rise. So this quotation has a very important impact of me being a researcher in the field of intellectual property law. I did art subjects in my A levels. So I read so many books. And this particular quotation from Kumartugga Munidas made a kind of a profound impact of thinking about creativity and ideas and knowledge and invention and innovations. And ultimately, I had the opportunity to enter into law faculty, and then I selected intellectual property law as one of my subjects in the final year. And then ultimately, intellectual property was one of the areas covered in my PhD research also. Okay, so Intellectual property law is or can be considered as one of the main branches of law which provides protection for creativity and innovation. Because without creativity and without innovation, we can't think of the development or achieving sustainable development even. Now, there are lots of discussions going on all around the world, even in the World Intellectual Property Organization level, even at the United Nations and other international intergovernmental organizations and NGOs and so on and so forth. How we can connect intellectual property with sustainable development. Because development without ideas and innovation or develop sustainable development without providing proper protection to new ideas or creativity or innovations would be a kind of an impossible idea or impossible task. Okay, so when it comes to intellectual property law, there are some fundamental aspects we need to consider. Okay, this is a kind of a very brief outline because we have only an hour or so just to discuss all these things. So I thought of narrow down my discussion onto copyrights and patents, because when it comes to intellectual property, just like a huge ocean or something like that. Okay, there are lots of different intellectual property. Trademarks are there, integrated circuits are there, geographical indications are there, plant breeders' rights are there, and unfair competition is there, trade secret protection is there. Okay, there are lots of different intellectual property rights. We may not be able to cover all the things here. So my discussion will be only focusing on copyrights and patents while touching the periphery of intellectual property law and the fundamental pillars or the aspects of intellectual property law, and also specifically AI implications on intellectual property law, because intellectual property law or intellectual property rights in nature very human centric. Intellectual property means contributions of human mind, outcomes of the human intellectual contributions are considered as intellectual property rights. However, when it comes to artificial intelligence, non-human intervention is there. Then there is a huge issue how we can accommodate non-human inventorship and non-human authorship in the context of traditional intellectual property right, because traditional intellectual property law is entirely designed or based on this human-centric nature or anthropocentric nature. Okay, so I'll be touching some aspects of AI implications on IP also. So when it comes to the definition of intellectual property, so this is one of the most comprehensive as well as one of the most simplest definition to the term intellectual property. Things made as a result of intellectual contribution of human mind qualifies to be considered as intellectual property. Things made as a result of the intellectual contribution of human mind qualifies to be considered as intellectual property. That the very definition indicates or signals a kind of a restriction or limitation to identify non-human creativity or non-human intervention in the context of intellectual property rights or intellectual property law. So, human intellectual contribution can be different. Okay? There are patents. Patents are granted for new inventions. Trademarks. Trademarks we use signs just to distinguish one good or service in a marketplace from similar types of goods or services. So then industrial design protects the aesthetic application of the aspects or the shapes of a product most of the time. And copyright deals with creativity and new ideas. New in the sense there are there are some issues going on, like whether we should protect ideas under copyright or we should only focusing on protecting expression of ideas under copyright law. There's a dichotomy. between idea and expression of idea in the regime or the area of copyright law. I'll be touching that aspect because we are going to discuss about copyrights. And then geographical indications. Perhaps you may be familiar, you may not be familiar with this particular term, but Ceylon cinnamon, Ceylon blue sapphires, Ceylon tea. These are famous geographical indications in Sri Lanka, and feta cheese, Kanchipuram sari, Mongolian camel wool, because these goods or services associates with the unique, could be a unique taste, could be a unique fragrance, could be a unique color because of the association of geographical factors. Could be the climate, could be the human factors, or that the traditional method of processing these goods and services or the foods. Okay, so that the geographical indications are also protected as intellectual property. And then trade secrets, Google algorithm. Okay, the best seller list of the New York Times, Coca-Cola recipe, KFC, fried chicken recipe. So these are some of the most famous trade secrets in the world. Trade secrets are also protected by intellectual property law or intellectual property rights and plant breeders' rights. And there are some other aspects for like unfair competition and passing off, so on and so forth. Okay, so intellectual property law covers all these different aspects of intellectual property. But when it comes to the core of the intellectual property law, there are three rights: patent, trademarks, and copyrights. These three rights are considered as the classical trinity of intellectual property. Classical trinity of intellectual property. Okay? Patent, trademarks, and copyright. Okay. So today we are going to simply only touch the periphery of two main intellectual property rights. Those are patents and copyright. So when it comes to the value of intellectual property rights, so the term property is there. Intellectual property. Property means a thing which can be owned by a person. This person can be a legal person or can be a natural person like us. Legal person like a corporation or a company, so on and so forth. Okay. So intellectual properties also can be owned, can be transferred, or even can be destroyed. When it comes to the concept of property or ownership relating to normal properties like movable properties and immovable property. If you own a car, it is a movable property. If you own a house, it is an immovable property. Okay, so you can transfer your property to someone else. You can simply sell your car to someone else. Okay, you can simply destroy your car even you want. Something similar to that, intellectual properties also can be owned, use and enjoy, transfer, because if you assume that you own an intellectual property, you own a patent. Okay, so you can assign, you can enter into a contracting agreement with someone else or a company just to assign some of the rights or all the rights relating to your person, your patent to a particular company or an individual. So something similar to physical property, intellectual properties can be owned, can be used and enjoyed, and at the same time can be transferred to someone. So that the proprietary characteristics of the intellectual property is the most important characteristic or that the aspect of intellectual property. Like you own your car or house, you can own your intellectual property rights, you can transfer your intellectual property rights, you can enter into contracting agreements relating to your intellectual property rights, and even you can simply destroy your intellectual property rights. However, according to Sri Lankan law, we don't really recognize this, the last right to destroy properties. According to Roman Dutch law, they says that there are three rights, putendi, putendi, abutendi. These are Latin terms, okay? So to use and enjoy, to transfer, and to destroy. So Sri Lankan law does not actually recognize right to destroy otherwise. So that the people tend to destroy their properties, which is not good. Okay. So when we look at the connection between intellectual property and knowledge economy, So intellectual property provides protection for diverse creations. As I mentioned earlier, patents, trademarks, domain names, geographical indications, all these different types of creativity, or that the results of creativity and inventions, or that the innovations are protected by intellectual property law. Because without protection, so for an example, so we all have 7 hours a week, 30 days a month, and 365 days a year. Okay. So a person, assume a person who is utilizing this very important, precious time to invent something new, while his friends or her friends or colleagues having like, that the different social gatherings and parties and like enjoying their life. Okay, at the end of the day, you invent something because of your hard work, dedication, and your contribution of intellectual contribution. Okay, so if you don't get any benefit out of your dedication and contribution and like utilizing your skills and judgment and your intellectual contribution, what is the purpose of creating new things if you are not protected by laws or that the relevant regulations or legal provisions? You could have simply like, that they visit your parents and relatives, and you could have engage in like, that the partying with your colleagues, utilizing the time that you utilize or devoted for creating something new. Okay. So incentive theory, there are theories of intellectual, why intellectual property should be protected. One theory is incentive theory, which means when you engage in intellectual contribution, intellectual property law provides you with some rewards. What is the reward? It protects your intellectual property and grants you a time-limited monopoly. Time-limited monopoly. This is very important. Time-limited monopoly, because when it comes to patents, exclusive patent rights are only for 20 years from the date of the invention. When it comes to copyrights in Sri Lanka, do you know the duration of copyrights? What is the duration? Yes, lifetime plus 70 years. Lifetime plus 70 years. Professor Edrivel Sarachandra's books are still protected because of this duration of copyrights. Lifetime of the author plus another 70 years. Okay, so that the time limited monopoly. Why time limited monopoly? Why? What is the reason? After this monopolistic time or the duration, it goes to the public domain. Okay, so when you invent new thing, when you obtain a patent license, after 20 years of time, your patented invention goes to the public domain, which means anyone in the public can produce the same thing and put it in the market and get the financial benefits. Because intellectual properties or the intellectual property rights are based on ideas or the knowledge. Ideas and knowledge always considered as a part of the public or the common good. Okay, just to incentivize creators and inventors, intellectual property rights grants you a kind of a time limited monopoly. Okay, after the duration or the particular time period, it goes to the public domain, which means knowledge is owned by public, ideas are owned by public, so that concept is protected by the very in the very foundation of intellectual property law. So that is why we are granted a time limited monopoly. Okay, so according to this incentive theory, and there are so many other theories, labor theory and reward theory, so on and so forth. Then intellectual property encourages innovation and strengthen economic growth. Therefore, having a very sound and comprehensive and robust intellectual property law in a country helps to protect diverse creations and encourage innovation in a country and strengthen economic growth. When we look at countries like Japan, South Korea, Malaysia, Singapore, Indonesia, Australia, and USA, so they have very complete, comprehensive intellectual property laws unlike Sri Lanka. So I have a very big concern, a big concern about Sri Lanka's intellectual property law. So it is high time to revisit the provisions of the existing legislation dealing with intellectual property rights in Sri Lanka. So then, intellectual property should be protected by law. Why? Because intellectual property rights are vulnerable. These rights can be subjected to theft and misappropriation. If there is no such right, or that the patent license is not granted to a particular person, so when you disclose your idea, or that when you publish an article relating to the invention that you invented, so someone else from somewhere else or some other country can just follow the step-by-step process you elaborate in your article and then produce the same thing and put it in the marketplace and get the financial benefits out of your invention, out of your idea, out of your contribution. So misappropriation and theft of intellectual properties can be happen. Therefore, intellectual property law provides a kind of an overarching protection to prevent misappropriation and theft of intellectual property rights. This is what the main objective of intellectual property. Okay. So this has been a kind of a concern among international community as well as national community. So when we look at the international law relating to intellectual property law, so it can be traced back to 1800s, like 1883, the Paris Convention for the Protection of Industrial Property was introduced, and then in 1886, the Berne Convention for the Protection of Literary and Artistic Work. So these two conventions were put together, and then after introducing the World Trade Organization in January 1st, 1995, they just adopted one of the most prolific and most accepted international legal document relating to intellectual property, the Agreement on Trade-related Aspects of Intellectual Property Rights, which provides minimum standards for protecting intellectual property rights. Okay, so World Trade Organization, there are 166 odd members of the World Trade Organization. Sri Lanka is also one of the early members of the GATT system and then World Trade Organization. So being a party to the World Trade Organization, we are bound by the provisions of the TRIPS Agreement. So in 1995, TRIPS was introduced, and TRIPS mandated member countries to prepare laws in line with the TRIPS provisions. Prepare laws in line with the TRIPS provision means, so they mandated that, okay, you are a member of the World Trade Organization, so you just revisit existing intellectual property laws of your country and check whether your laws are in line with the standards we laid out in this particular agreement. Then as a result of that, in 2003, Sri Lanka enacted a comprehensive intellectual property code for the country, which is Intellectual Property Act number 36 of 2003. So Intellectual Property Act number 36 of 2003 is the governing regulation or that the law that we have. But when we look at Australia, even India and Singapore and other countries, they have separate laws dealing with different aspects of intellectual property, like Patent Act, only for patents. Okay, Trademark Act for trademarks. Geographical Indications Act, just to cover geographical indications. The Copyright Act, just to cover copyright. But we have a comprehensive code which encompasses all the intellectual property rights. Okay, anyhow, said the Intellectual Property Act provides comprehensive protection for intellectual property law. So even after 2003, this Doha Declaration, perhaps you may be familiar with the term Doha Declaration, just to cover up the public health aspects of intellectual property rights. And also in 2020, TRIPS waiver proposal was introduced just to make sure that the advancement of intellectual property should be distributed among each and every country, irrespective of their financial capacity or the developing and the development status. Okay, because COVID-19 hit in 2019, and then vaccines were invented by different pharmaceutical companies. So once you get the patent license, you can decide the price of the product also. And also you can take whatever the decisions relating to production. Okay, how many, like, the vaccine doses that you are going to produce, whether you are going to export your vaccines or not, if you are going to export for what countries, every production related decision can be taken by a patent owner. So this has created a kind of chaos among international community, because even in Sri Lanka also, I think we did not have access to a kind of like better vaccines in Sri Lanka, like Moderna and Pfizer and other vaccines. Okay, limited vaccine doses were received by many developing countries. Okay, so just to mitigate these type of, because intellectual property law does not always provide protection for each and everyone in the society. So the intrinsic nature of the intellectual property law is that to protect the creators, protect the inventors, and the owners and authors of intellectual property rights. Okay, so there should be a proper balance between public interest and protection of intellectual property rights. So that's why these different declarations and conventions were introduced later on. So copyright is one of the main intellectual property rights, as I mentioned earlier, belongs to this classical trinity of intellectual property law. So copyright is a legal right granted to a creator of an original work. Could be a book, could be a song or a video or artwork, giving them exclusive rights to use, reproduce, distribute, and profit from that work. To use, reproduce, distribute, and profit from the work. So these are the bundle of exclusive rights associated with copyright protection. And also, perhaps you may remember I mentioned in the beginning, there is a dichotomy. There is a kind of like, the kind of an issue whether we should protect ideas using copyrights, or whether you should only focus on expression of ideas in copyright, because idea belongs to general public. Okay, when it comes to the protection of ideas, so intellectual property law may create so many different difficult issues in a society. Okay, someone could say that, okay, this idea belongs to me, so I have copyrights, which means lifetime plus 70 years. So if you are going to create something new on the same idea or based on the same idea, you have to get my authorization. If I don't authorize, what will happen? You will be violating my intellectual property rights. So that's why intellectual property law only focuses on, especially copyright law, only focuses on protecting of idea, not protecting of the expression of idea, not ideas itself. So look at these two photographs. Okay, so Sigiriya rock fortress is there. Two photographers have taken two photos. Okay, so idea is similar and identical, but the angle and the resolution and the way in which that photographers have taken these photos are different. So both photographers can claim intellectual property rights over their photos, because based on the skill and judgment and the labor they devoted in taking the photograph. So idea is same and similar and identical, but the way in which they express the idea is different. So both photographers can claim intellectual property rights or copyrights over their photographs separately. So photographer 1, lifetime plus 70 years. Photographer 2 also gets the same intellectual property protection under copyrights. So that's why we rely on expression of idea rather protecting ideas. If idea to be protected under intellectual property law, then the second photographer may not be able to claim intellectual property rights over his or her creation. Okay, thus both should be able to prevent other person from printing copies of their respective photographs. Not only printing, but like that the selling and like translating and adapting and putting it even in the visual of a song also can be prohibited or prevented by using intellectual property rights, especially copyright provisions. So when it comes to copyright ownership, this is a kind of a tricky aspect, copyright ownership. So there can be owners and authors, owners of copyright and authors of copyrights. Okay. So author is the creator of a work and the first owner of copyright. If you create something new or new idea in the sense like expression of idea, okay, not the idea itself. So you will be considered as the author of such. You can be the owner of your work also if there is no such other person who can control your work. For an example, I'll give you an example later. So just look at the definition of copyright owner. Owner of copyright is the person who has plenary or complete control over the work. Complete control in the sense the owner of copyright can take all the decisions. How we are going to commercialize your copyrighted work, whether you are going to adapt or whether you are going to authorize your copyrighted work to be adapted as a film or a song or a broadcasting program, so on and so forth. All these intellectual property related decisions can be taken by the owner. So then, can you give me an example? Or perhaps I think I have to give an example. Okay, so I should not be asking questions from you. So you are university academics and researchers. Okay, so when you write something new, okay, utilizing your skill, labor, and judgment, so that because copyright protection is automatic. This is very important. Okay, in Sri Lanka, copyright protection is automatic. Automatic in the sense when you express your idea in an innovative way or a novel way, in a creative way, using your skill, labor, and judgment, so you get this lifetime plus 70 years protection. But in countries like, not in USA, but some countries like New Zealand and even the UK is going to introduce this copyright registration system. So you don't get automatic protection. You have to just go to the National Intellectual Property Office or the dedicated office in the country just to obtain the copyright protection. But in Sri Lanka, still, we just follow the British system or the common law approach. So you get the automatic protection. Okay. So you as an academic or a researcher, when you create something new, so you will be getting copyrights as the author of copyrighted work. But there may be IP and commercialization policies in the university. Okay? The policy may indicate that the university as the owner of your copyrighted work. In that event, sometimes there may be, you can take some decisions as the author, but as the owner, reproduction and distribution and selling related decisions can be exclusively taken by the university because university is the owner, or that the a person or entity which is having the complete control over copyrighted work. So my suggestion is that so all the postgraduate students and even academic staff members should be given an idea about this copyright and commercialization, IP commercialization policy of the university. Then they know that, okay, so if I, as a postgraduate students, when I submit my thesis, so the copyrights vested with the university. Students will only be considered as the author of the work. The owner of the work will be the university, and also university, there can be some compromise also. Compromise in the sense, so there can be different agreements with the students and the university and the researchers at the university or academics and the university regarding the terms and conditions of ownership and authorship because authorship is a kind of a very well established and recognized concept, so that even though university is the owner of the copyright, university cannot, like simply neglect the authorship because you are the author. Okay, so the ownership directly dealing with this economic rights of copyrights. There are two types of rights associated with copyrights, economic rights and moral rights. So authors have moral rights. If you are the owner of your work, you have economic rights also. If someone else is the owner always enjoy this more economic rights. So author means in relation to a literary or dramatic work, the author of the work, musical work, the composer, artistic work other than a photograph, the artist, photograph, the person taking the photograph, cinematographic film or sound recording, the producer, and in relation to any artistic, literary, dramatic, or musical work which is computer generated, the person who caused the work to be created can be considered as an author. This is an example which can be directly relating to a university setting. Okay, a university lecturer writes a book, textbook for their course. Once the textbook is written, it is automatically protected by copyrights. This means no one else can photocopy large portions of your work, sell copies, or upload it online without your permission or without the permission of the publisher. There may be an agreement between the author and the publisher saying that, okay, so you just publish our book, we get only like 10% interest or that the kind of honorarium or payment out of whatever the the financial benefits getting by the publisher. This happens all the time with academic publications at university level. So if you are to that they go with this um, like very popular publishers like Oxford University Press and or Harvard University Press and some other I'm not familiar with the publishing companies in your discipline, so I'm familiar with legal discipline and related public publishers. So there may be an agreement with the author and the publishing company. Okay, so when we refer to the economic rights are also very diverse. Diverse in the sense they are a bundle of rights, so that the bunch of rights associated with the owner of a copyrighted work. Right to reproduction, to make copies of work in any form, print form, digital form, or electronic form, because according to WIPO Internet Treaties, World Intellectual Property Organization Internet Treaties, which were introduced in 1996. So now we just communicate our works not only through the physical modes, like electronic versions and digital versions are also there. Okay? Perhaps there may be journals, we have online version as well as a printed version. Okay, so right of reproduction, right to distribution, to sell, rent, lend, or otherwise distribute copies to the public. And right to communication to the public, to make works accessible to the public through broadcasting, streaming, online platforms, and right to public performance also associated with the copyright owner under economic rights. And there are some other rights also, right to translation, to translate the work into another language. So in the event you are going to translate one of the famous textbooks in your discipline into your own language or mother tongue, so you need to get the copyright authorization from the author, or perhaps you need to contact the publishing organization or the authority. So without getting any authorization, when you translate your work, it will be considered as a violation of copyrights of the owner and the author of the copyrighted work. For an example, if a Sri Lankan is trying to translate Harry Potter book series into Sinhala language, they need to get the authorization from the relevant author and the publishing company. And then right of adaptation or derivative works, to transform the work into new form, like film adaptations or musical arrangement. Like a book we convert into a film. When we are converting a book into a film, again, we have to reach out to the author of that work or the owner of that work and then get their authorization or enter into a licensing agreement. And then right of rental and lending, specifically for computer programs, films, and sound recordings. Okay. So this is an example for economic right. So I have used the Open University's context. A lecturer at the Open University publishes a textbook developed during university-funded research. Because we have a copyright policy, comprehensive copyright policy. So if the research is funded by the university, according to this copyright policy, the university is considered to be as the copyright owner. You will be considered as the author, but owner is the university, which means the rights we discussed, like reproduction, communication, rental, adaptation, translation, all the rights associated with the university. Okay, so the university holds the economic rights and can reproduce and distribute the book through OUSL Press for profit. No other party can legally reproduce or sell the textbook without authorization. Okay, so again, economic rights are considered to be as time-limited monopolistic rights. So this is a copyright note which I have taken from one of the course materials of the Open University. So that I think Morato University also in your publications you have copyright notice, right? Journals and other things. Yes. University. Yes. Yes. If it is a kind of an individual work, not commissioned by the university, no, then they gets the copyright ownership and the authorship also. Authorship is there. So we normally put this type of copyright note in each and every course material because our university is entirely based on course material based teaching. So we have to assure that intellectual property rights are protected. So then the second type of rights is moral rights. Okay, so when it comes to intellectual property rights, there are two types of rights, economic rights and moral rights. So moral rights are personal to the creator and are independent of economic rights. There can be a separate author and owner. Moral rights always associated with the author. This is what the most important thing. So there are three types of moral rights: right of paternity, right of integrity, and right to prevent false attribution. Right of paternity means to be identified as the author. Even though university holds copyrights, if you are the creator of that original work, you should be identified as the author of that work, even after thousands of years. This is what the most important aspects relating to intellectual property rights, especially moral rights of copyrights. Even after thousands of years, you should be considered as the author of that work. Economic rights are limited to the time duration, which means lifetime plus 70 years. Moral rights does not associate with any such limitation. In that event, moral rights are infinite. Or moral rights can be considered as an everlasting right. So we still refer to Shakespeare's Macbeth. Okay, Maname, written by Professor Edrivira Sarachandra, because of this moral rights. Okay, and right of integrity means to object of distortion, mutilation, or modification that harms creator's reputation. Okay, sometimes a new upcoming singer may need to include a kind of a rap version into a kind of a traditional Sinhalese song. Okay? The composer, lyrics writer, and the producer of that particular song can prevent the new generation singer from including a kind of like rap version into that song based on this moral rights, right of integrity, and right to prevent false attribution, to stop others from being presented as the creator. This happened in Lalita Sarachandra versus Upul Shanta Sannasgala, a quite famous case. Actually, in the class, Upul Shanta Sannasgala has printed his name because Maname was the recommended drama for A-level art students sometimes back. So he distributed this particular booklet in the class to the students who attended the class. in the cover of that book, he has not mentioned the name of Professor Ediri Veerasarachandra, but mentioned his name, Upul Shanta Maname, Upul Shanta Sannas Gala, which is wrong. So right of paternity is there, right of integrity is there, right to prevent false attribution is also there. So that the Maname is originally written by Professor Ediri Veerasarachandra. He should be recognized and identified as the author of Maname even after 1,000 years, even after 1,000 years. Okay, then it went to the courts and it went to commercial high court, and the commercial high court decided in favor of Upul Shanta Sannasgala's wife, Lalita Sarachandra, and then there has been a kind of a mediation process, and then it settled, but it discusses about this moral rights. And the argument of Upul Shanta Sannasgala was that the booklet was freely distributed in the class. Therefore, it comes under fair use exception. But then the judges of the commercial high court, they were very that they're reluctant to accept that particular argument. Then they said that, okay, the booklet was distributed in the class free of charge, but to attend the class, students had to pay some class fee. Therefore, there is a commercial interest. Therefore, it cannot be or should not be considered as fair use, or activity comes under the scope of fair use. Okay, so this is an example of a moral right, or how to recognize moral rights. A video lecture created by one of the senior academics using an online course. Another party edits the video in a way that misrepresents the academic's view or fails to credit the author. This will violate the creator's moral right. Okay, so in that event, this is an example. I just wanted to highlight it here. Perhaps you may see here. Most of the sessions of this family law course book were written by late Mr. Rohana Ratnayaka, and we would like to acknowledge his valuable contribution towards the development of this course material. So we had a full revision of the course. So we introduced new cases and recent developments, and again published the course material, but we acknowledge the original authorship or that the contribution of the particular person who contributed to develop this course material initially by way of recognizing moral rights. Okay, so now we have some idea about copyright. So copyrights are bestowed upon creations, expression of ideas, not on ideas. So there are two types of rights associated with copyright: economic rights and moral rights. So moral rights are infinite, everlasting in nature, but economic rights are time limited, exclusive rights. Okay, so when it comes to patent is a government granted exclusive right that protects new and useful inventions for a time period, limited time period. Again, limited time period comes. Okay, encouraging innovation by rewarding inventors. Okay, I have taken this case from United States, Diamond versus Chakrabarty. In this case, actually, the matter was based on oil-eating bacteria. Oil-eating bacteria. Okay, so the court decided, actually there was an argument for and against of granting patent on this oil-eating bacteria. And one of the arguments is that bacteria, oil-eating bacteria is only a discovery, because when it comes to intellectual property law, discoveries may not be able to be qualified as patentable inventions. Near discoveries are not patentable. Okay, but the court decided that oil-eating bacteria is not a mere discovery. So there has been an inventing process, and there has been skill and judgment and labor invested in finding this oil-eating bacteria, and it fulfills all three criteria of patentability, which is novelty, inventive step, and industrial applicability. There are three criteria to be fulfilled. I'll be discussing three criteria later. So, and then the court decided that anything under the sun that is made by man is eligible for patent protection. Okay? The USA is very, very thorough and very strict about intellectual property protection. Even in their constitution, Article 7 refers to intellectual property protection. In our constitution, we don't even have right to life recognized as a fundamental right, but in their constitution, they have recognized intellectual property as a fundamental right in the US Constitution. Okay? They are that much of like, that the um, focused on protecting intellectual property rights because they know the real value of intellectual property rights. So when it comes to patents, anything under the sun cannot be patentable. Patentable in the sense because there are some exceptions or limitations to patentability. As you can see here, this is similar. This section is similar and identical to Article 27 of the TRIPS Agreement. Perhaps you may remember the TRIPS Agreement. TRIPS provide the minimum international standards relating to intellectual property rights. So according to Article Section 62, subsection 2 of the IP Act, the followings are not regarded as invention in the meaning of an invention in the Act. Discoveries, scientific theories, and mathematical methods cannot be considered as patentable inventions. Plants, animals, and other microorganisms other than transgenic microorganisms. Schemes, rules, or methods for doing business, performing purely mental acts, so playing games. There's a kind of a big list, okay? So this is not an exhaustive list. I have taken only one part of this section. There are some other things that cannot be considered as patentable inventions, okay? So transgenic microorganisms can be patented. This is an example. Process modified with fancy genes to express the blue color. Okay? So if it is there in the nature, if it is only a discovery, if it is only a discovery of a microorganism, so that type of discoveries cannot be protected by patent law. But transgenic microorganisms can be protected. Okay? You may be able to grasp this idea because you are inherently well equipped with the knowledge related to these scientific terms and like scientific things. Okay. Then when it comes to patent or that the patentability, there are three things to be established to obtain patent protection. Invention should be a new, it should involve an inventive step and are capable of industrial application. So when it comes to traditional Sinhalese medicine, what is lacking? So our Sinhalese medicine is novel. Inventive step is also the industrial applicability we know. So that the Japanese and US companies, they have taken the Kothalehimbutu and other medicines to their countries. They just produce some pills. Industrial application is there. So they obtain the patent protection. But the traditional method of curing diabetes is coming from Sinhalese traditional medicine system. What we are lacking is that industrial application, because if you cannot prove all three criteria, you may not be able to obtain patent license. Because we simply and blindly follow the standards set by the TRIPS or the World Trade Organization. We should identify the realistic and like actual needs of the country, because Sri Lanka is a very diverse country, biologically rich, and we have like 1,000 years of history. We have these traditional medicine systems and we have folklore. We have so many things, but our intellectual property law is designed not to accommodate these specific considerations, but just to make sure that we follow the international rules and regulation, and to say that World Trade Organization, oh, okay, you wanted us to be TRIPS compliant. So we enacted a brand new legislation in 2003 just to make sure that we follow all the provisions outlined in the TRIPS agreement. In the TRIPS agreement, there are provisions relating to protecting of wines and spirits as geographical indications. Sri Lanka, we don't produce wine and spirits. Okay? We produce non-alcoholic geographical indications all the time. But we don't have provisions to protect non-alcoholic GIs in the country. We have provisions to protect wines and spirits, even though we don't produce wines and spirits. So this is a kind of a critique, okay? So these are the three criteria of patentability: novelty, inventive step, and industrial applicability. In the interest of the time, I'll be simply touching the three criteria. First one, novelty. An invention must be new at the time of filing the patent application. An invention is not novel if it has been anticipated by prior art. Prior art means prior art could be a written publication, oral disclosure, public use, or exhibitions, or any other form of disclosure. So when you invent something new, so before publishing it, if you are to obtain a patent license, if you have any intention of obtaining a patent license, you may need to be careful about this disclosing of that particular invention to general public. Okay. There is an exception. Exception is that, so if you are going to file your application within 12 months of such disclosure, so your publication, assume that you just engage in a research with your supervisor as a PhD or an MPhil or a master's student. Okay, so you find something new and groundbreaking. Okay, so that your supervisor encourage you to just to publish it in the Q1 top tier journal. You just publish it. Getting published in the Q1 journal itself take like at least 1.5 years or 2 years. That is something. Is that so? In law, I don't know, in engineering and other disciplines, in law, depends on the journal. Normally, it takes at least 2 years to publish in Q1 or a top tier journal in the discipline of law. Okay? So, but you may not be experiencing that type of difficulties perhaps, okay? So, if you are filing the application within 12 months from that disclosure, so you can still get the patent license. Your own publication may not be considered as prior art or disclosing your invention into general public. Okay. Otherwise, there is no exception. If it is published, if it is there in the existing knowledge, so your invention will not be considered as novel. You may not be able to fulfill the first criteria. Okay. So the second absolute novelty requirement is the absolute novelty in the sense when you file an application in the patent office, Sri Lankan patent office will reach out to almost all the patent offices around the world and check with them whether there is similar and identical product or process mentioned in this application. So that is why patent application, they take like at least 2 years, 2 to 3 years, right? Or perhaps 1.5 years if you are really lucky. Okay. Then the second criteria is once you prove the novelty criteria, the inventive step is the second criteria. So second criteria is the most rigorous criteria to be fulfilled. Rigorous in the sense, so they just consider a kind of a hypothetical test. Patent examiners consider a hypothetical test. An invention involves an inventive step if it is not obvious to a person having ordinary skill in the art. We call it Foshita test. A person having ordinary skill in art. Non-obviousness means a mere difference from prior art is not enough. For an example, assume that you own this one of the paracetamol companies in the country. Okay, so you just get the patent license and you get whatever the exclusive rights associated with the patent license, and you just get the financial benefits and everything for 19 years. Okay, duration of patent is 20 years. In the 19th year, now you consider about your patent license or the protection. You just change the shape of the tablet and apply for a new patent. Okay, so that is why patent office apply this rigorous criteria. If there is an obvious change, obvious changes cannot be considered as inventive step. Okay, a mere difference from prior art is not enough. The difference must be significant. The difference must be significant. Okay, to measure this significant difference, they just refer to this hypothetical situation. Here, there are some examples when you can, you may be able to get some idea. In the tea industry, a novel tea processing method that increases flavor retention using an unexpected humidity temperature cycle could be an inventive step when we hypothetically apply the knowledge of a person skilled in that art in the sense tea industry. So we can't ask a lawyer's knowledge to that the imputed into that situation and ask that lawyer whether you recognize any such inventive step in this process. Okay, we have to a normal person skilled in the art means we have to always refer to that particular industry, skilled in the industry. So you are from engineering discipline and science discipline. So one of your professors, so that the normal person is skilled in the art, identify there is a kind of a significant change or that the significant development in a particular product or a service or a process. So that will be adequate. That assurance will be adequate or would be adequate to fulfill the certain criteria. This is the most rigorous criteria. So novelty we can prove. If it is new, if you cannot find any such disclosure in the existing knowledge, you can prove that, okay, the invention is new or newness is there. But when it comes to inventive step, if it is new, if there is no significant change introduced by the invention, then it may be difficult to prove the novelty criteria. Okay. And then the third criteria, industrial applicability. Under Sri Lankan law, an invention shall be considered industrially applicable if it can be made or used in any kind of industry. So this is what happens with Sri Lankan traditional medicines. Okay, පතාට එකට සිදු වීම කියලා අපි කියන්නේ. So that process takes time. Okay, so you have to use earthen pots and you have to use traditional type of the boiling these things. So industrial applicability is not there. Okay. So in some countries like Malaysia and Japan and Thailand and most of the technically developed and advanced countries, they have this petty patent system or second tier patent system. In second tier patent system or petty patent system, they just have some lenient criteria. So these thresholds are very high. Novelty, inventive step, and industrial applicability, these thresholds are very high threshold. These high thresholds can only be met by or fulfilled by most of the very sophisticated inventors. Okay, to provide solution, these countries have introduced petty patent system or second tier patent system. The criteria seems to be a bit low, and the protection is also that the duration is also low. Perhaps like not 20 years, 10 years protection. That is enough actually just to encourage small and medium-sized enterprises and the individuals who invent new things. But in Sri Lanka's existing system, there is no way. So you have to fulfill all the criteria, so all high thresholds in order to obtain patent licenses. When we look at the statistics of the patent office or the IP office of Sri Lanka, we see that most of the foreign patents or that the patents filed by the foreign companies, there is a tendency towards obtaining patent license because they can easily meet these three criteria, high thresholds. Most of the locally filed patent applications seems to be failing because of the fact that inability to meet the high thresholds set in the National Intellectual Property Act. Okay, so this is one of the issues. Anyhow, if you can meet these criteria, you can obtain patent protection. Okay, so these are the exclusive rights associated with the patent license: right to make the invention, right to use the invention, and right to sell or offer for the sale, and right to import the invention, right to license the invention, and right to assign or transfer. So overall control of invention is bestowed upon the owner of the patent or the patent owner. We take all the production, distribution, selling related decisions. So that's why these pharmaceutical companies, most of the time when the international community is going to introduce some exceptions, looking at the access to medicine and related considerations of the developing countries, countries like Switzerland, Japan, USA always oppose these proposals at international level forum, saying that there are enough exceptions. We should not introduce new exceptions, so on and so forth, because these pharmaceutical companies are housed in these sophisticated developed countries. AstraZeneca, Pfizer, and all other the pharmacy companies are housed in developed countries. So developed countries, they just oppose all the time when countries are going to introduce some exceptions relating to licenses. Okay, so this is the last segment or the last part of the discussion. So human and non-human authorship. So when we looked at the existing, like that the design or that the structure of the intellectual property law is human-centric. Okay, lifetime of the author plus 70 years. It's very simple. So AI cannot be considered as human or that the living thing. So the very nature and the wordings of the Intellectual Property Act does not recognize or even not tend to recognize non-human authorship. When we look at these sections, economic rights are bestowed upon the authors, human authors. Moral rights are bestowed upon the human authors. Term of protection refers to lifetime of the author plus 70 years. The wording itself refers to the human-centric nature of the intellectual property law and the copyright law. Then there are ambiguities whether we can protect AI-based works, because AI-based works can be divided into two categories: AI-assisted and AI-generated. Okay. So there are lots of discussions going on in different countries, whether to recognize non-human authorship in the context of intellectual property law, or whether to just simply reject the recognition of non-human authorship in the existing intellectual property law. Okay, this is an issue. There are lots of different discussions going on. AI generated works, autonomous works based on AI may not be recognized by any country. When we look at sophisticated jurisdictions like UK, USA, Singapore, India, and other countries, there is no such tendency in recognized autonomous AI works in the context of intellectual property law. But there is a tendency towards recognizing AI-assisted works, just to recognize perhaps the user of that AI application, or perhaps the creator of AI application as the owner of that AI generated, AI assisted work. Because otherwise, who is going to utilize these economic rights? We can't ask artificial intelligence just assume that we are going to use ChatGPT to create an image. Okay, so if we get the same type of intellectual property rights, copyright protection, which associated with moral rights and economic rights, okay, can we ask ChatGPT just, okay, you have reproduction rights, you have adaptation rights, you have public performance rights, everything you have, now you just utilize, we can't ask. Okay, that is why human-centric nature of intellectual property is very important. Okay, countries are having discussions. So in Sri Lanka also, the white paper will be released very soon. So I'm also one of the members in that committee. So we have drafted a kind of a comprehensive proposal for Sri Lankan law. What provisions in what legislations need to be changed just to accommodate artificial intelligence implication on intellectual property and all other laws. Privacy, constitutional law, online safety, all other matters, including intellectual property rights, because we cannot say no to the development of the technology. Okay, so we have to absorb, but we need to preserve the, like, you know, the existing structure, or the good theoretical foundations of existing legal principles. When it comes to non-human inventorship, actually, big no from every countries. When it comes to non-human authorship, there seems to be some kind of recognition in different countries, but when it comes to non-human inventorship, big no from USA, UK, Australia, and all other countries. One, there's a famous person, Thaler versus, he invented AI application called Debus or Dabas. So using that particular application, he created new things, and he filed he's going filing cases in different countries. Okay, he went to US patent office. They rejected, saying that okay, we should not give inventorship to a AI application. So they rejected. He went to the courts. Okay, when a patent application or intellectual property protection is rejected, there are provisions to be going to the courts and then implement that, get a verdict against the decision of the patent examiners. Then the same application filed in the US Patent and Copyright Office, also UK Patent and Copyright Office, they rejected. He went to the UK courts. UK courts also said that our Patent Act is very clear. A human inventor should be the only type of inventor should be recognized by law. Then rejected. Then he went to Australia also. In Australia, actually, what happened was Australian Patent Office also rejected the patent applications and stating that the invention is done by an artificial intelligence application. So inventor is not a human inventor. We cannot recognize. He went to Australian Federal Court. Australian Federal Court is like the Supreme Court of Sri Lanka. So they have Supreme Courts in each state, and the Federal Court is the Supreme Court. So in the Federal Court, what happened was that that particular judge, Justice Breach, recognized non-human inventorship and established that non-human inventors can be considered as inventors in terms of the existing provisions of the Australian Patent Act. This created chaos in the country, all around the world, and then Supreme Court appointed a full bench. Full bench means consisting of all judges. They revised the decision of one bench decision given by Justice Beach, stating that no, non-human inventorship should not be recognized. The current situation all around the world is that non-human inventorship should not be recognized. But non-human authorship, if it is a work, if it is an AI-assisted work, can be recognized only for some specific purposes. Okay. So this is the summary. So we discussed about intellectual property law and intellectual property rights, and we discussed about the importance of intellectual property law, and we refer to copyrights and patents also. We try to understand the difference between these two concepts, and we understood that copyright dealing with expressions of idea, patents are dealing with newness, or that the novelty, inventing new thing. And there are emerging issues, whether and how we accommodate AI-generated and AI-assisted inventions and creations in the existing intellectual property law. Okay, that's it. So if you have any questions, or if you need to get any clarifications, we can have another 10 minutes discussion, Professor. 10 minutes. Yes.
So, how can we protect, how can an author protect his work used elements? Because, as for example, if I copy something from there, you can see that I did that. But when LLM use someone work, we can't see because it is hidden in the algorithm and in the steps. So, in that case, I will be.
So if you are going to use a significant part from that particular author's work, I think that the library can involve, they can just write to that particular author or the university or the publishing company to obtain the authorship. Because you can simply mention that a state university has a particular purpose. Purpose is to provide free education to the, but when it comes to postgraduate, that we cannot simply say that we provide free education, because we just like, they are supposed to be paying some fee. In that event, that commercial purpose is there. Otherwise, that the fair use exemption, if you refer to section 14 of the IP Act, there are list of occasions where we can use this fair use exception. If it is purely for an individual use, if it is purely for an academic purpose, if it is purely for an individual research purpose, actually we should not be even like communicating or that the obtaining authorization from the copyright owners or authors. But if you are going to upload it in the LMS page or upload in the university level website, it is always better to reach out to the relevant authors and owners and obtain the authorization or the permission. Sometimes they may say that, okay, so they may look at your university profile and your objectives, and they may say that, okay, so this is for educational purpose. So without having any reservation, I give my full authorization for you to use perhaps the entire book as recommended reading. Even recommended reading, when you're uploading recommended reading onto your LMS page, before that you need to get the copyright authorization, at least for a chapter. Sometimes they may not be able to tackle all the things, because now we are living in a kind of like universal village. So that the technology is very fast and very quick. So all the documents, one document can be like, within milliseconds can be distributed among all over the world. Okay, as an author, I may not be able to tackle all these type of violations. Okay, so but it's good and ethical principle if we have that kind of mechanism actually just to check it. And in Open University, there's a mechanism. So we have a center called Center for Education Technology and Media. Okay, so when we prepare LMS, so we have a checklist. Okay, upload links and videos and all the things. So before publishing it to the students, we send to the Education Technology and Media unit or the center. What they do is that they just go through each and every material and recommended video and everything just to see whether these materials are open access materials or copyrighted materials. If they are copyrighted materials, they refer back to the relevant lecturer or to the department and ask us to obtain copyright authorization through the library or write to the relevant authors or the owners of copyrighted work, and then obtain the authorization. Then only they are going to publish these links and videos and materials on LMS pages. We normally follow that process, and also we can simply refer to the open access knowledge or open access works.
Thank you very much for your interesting and very comprehensive presentation, and I think we all learned a lot from the session. I have some questions with regard to authorship and ownership. Now, while you're explaining, you mentioned that if it is a university-funded project and you are writing a book or a paper, the ownership needs to go to the university, ownership to the real world, the
Yes.
researcher.
Yes.
So any other situation where we have to provide the ownership to the university? What are the other circumstances? Because I'm just worrying, because I feel like both ownership and authorship needs to lies with the
Same
researcher
person.
or
Yes.
the lecturer.
Yes.
So other than university funded project, any other areas or any other things that we needs to look for giving the ownership to the university?
Okay, so actually most of the time authorship and ownership always vested with the author. Okay, if it is not a university funded project, definitely assume that you are going to conduct a research and then you publish it in a journal. Okay, so you are the owner and you are the author. University has nothing to say about it. Okay, but there may be occasions university have a kind of a university maintains a kind of a norms document. Norms in the sense norms for academic members of the university. In that norms document, there may be a specific provision referring to the development of course material by the academic staff members. Okay, so academic staff members course development activities as a part of the norm document. So the academic staff members are considered to be as employees of the university. So when it comes to intellectual property law, if someone commissioned you to do a task, the person who commissions you owns the intellectual property rights. So you can have a separate agreement. Sometimes you may have a separate agreement and say that, okay, I'm an independent researcher, so I should be the owner as well as the author of the copyrighted or intellectual property creating as a result of this particular research work or something like that. Other than that, if there is no such express agreement, according to the existing agreement, you will be the author and the person who commissioned you to do that work will be considered as the owner. Open University, what happens is that, so we extensively rely on this course material because we follow this open and distance learning. So it is a mandate of each and every academics to engage in course development. For an example, I recently introduced health law into legal curriculum for the first time in the country. So I wrote an entirely new book for health law. I am only the author. University is the owner. Okay, even though it is the very first health law book in the country, so according to notes document, I should be developing course material. So university holds the copyrights ownership of that particular course material. I am only the author. So that type of examples maybe they are in different universities. Anyway, it is better to have a very comprehensive IP policy in each and every university, just to make sure how this ownership and authorship debate can be resolved, so on and so forth. Otherwise, there will be lots of different issues.
Yes. Yeah, things so the work is patented or not. So how can we verify it?
For that, I think you can get the support of a patent filing attorney, or I think in Colombo University, I have seen they have this business liaisons. In Open University, we have Industry Liaison Center. In Colombo University, IBL, Industry Business Linkage is there. So that is the focal point. Okay, she is here, so you have to reach out to her and have a discussion, and then she'll be able to guide you because they have connections with industry also. So industry experts are there, so you can obtain the expert opinions from industry experts through the IBL, UBL, I think, University Business Linkage Unit. They are supposed to be providing that service, okay? So you can just bother her and get the advice. Okay, if there is no question, so we can end the session. Thank you very much.
Thank you very much, Professor, for that impactful, enlightening session. I would say the session was very structured, and you made sure that everything was explained from the ground level so that we laymen understood it really well, and covered a lot of points that patents, copyrights, and trademark, everything was very important for us. And we are very grateful, and your expertise and everything that you said here was very important for us, and we are very, very thankful for that. So to appreciate that, to present a small token of appreciation, I now invite Professor Ruwan Gopura, Dean, Faculty of Graduate Studies, to present a small token of appreciation. So I would like to invite you to the front once again.
Okay, thank you once again for inviting me and your hospitality. Thank you.